Good afternoon, everyone, or good morning. My name is Dave Bailey. I'm the Vice President of Healthcare Services for CTEK. I've been with CTEK for 5 years, for those of you that don't know me, and have the opportunity to lead a outstanding delivery organization. As part of that process, have an opportunity to work with many clients inside the healthcare industry, and this is a topic that certainly is extremely challenging today as we try to address risk, and certainly I don't think any organization can operate today without having and relying upon vendors, and part of that process is helping manage and safeguard the critical information that we have to ensure that we have the right controls in place, and helping with that partnership. So happy to be here today. I'm joined by two outstanding professionals and folks inside our delivery organization. The first of those being Andrew Muller. Go ahead, Andrew.
Hi, welcome everybody. Thanks for joining.
And Ratana.
Good afternoon, everybody.
And throughout today, Andrew and Ratana will have an opportunity to provide interesting insight from overall a security and compliance perspective. And with that said, I'd like to dive right into the content. So next slide, please. All right, we're going to start off this session today with asking some poll questions. So what I'd like everyone to do is make sure that they look at their polling tab and provide answers to the questions as we start this. So first and foremost, does your organization have a vendorous program? Well, the good news out of this, as I watch the results come in, is that a majority of the answers so far, about 66% of you are saying yes. About 25% or less says that they have something, but it's informal, and some only a process when it deals with IT systems. So, all right, I think we settled in on that. 60, about almost 70%. So yes, they have programs, just shy of 12 for IT systems, and shy of 20 for informal. All right, next slide. All right, next question is approximately how many vendors do you contract with? All right, this is a fun and exciting one for me. Right now, leading the way is around 40, almost 43% with not sure. 14% with 0 to 100. About 29% with 100 and 1 to 500, and 14% with more than 500 vendors. Certainly, I think no matter what size or how many vendors that folks have to manage, when you start to get to the numbers, and I've worked with some systems that just have hundreds, if not thousands, of vendors that they have to manage as part of overall risk management program. So ultimately, from a not sure perspective, the systems in place can certainly help identify those vendors and make sure that the appropriate safeguards are being met. So, all right, next slide. And what at your organization is responsible for oversight of vendors? And this will be the last question. So this is really, is there just one entity, multiple entities? All right. Absolutely, by far leading this charge is multiple offices. Less than 20% at only one office, and 17% don't know where the oversight resides, and just shy of 9% is multiple offices but no collaborative process. So opportunities, as we like to say, those are really good opportunities to ultimately help grow and mature a program. So. All right, thank you so much for participating in those polls. It's extremely valuable information as we just get a good understanding of where everyone is at and how it lines up with generally what we see as we look across, all of the industry. So certainly appreciative of participation in that poll. Go ahead, next slide. And one more. I'd like to set the scene. Two very important things that I want to set the stage as we go into this vendor risk discussion. First and foremost, Synergistic produces an annual report. We released that report in the summertime, and really it's an opportunity to take a look at all of our 2020 risk assessments that we performed, and as you look across the industry and you really summarize things up to the top, what we did notice was that the supply chain portion of the NIST cybersecurity framework was the lowest scoring category from an overall conformance perspective. And certainly we saw that there were not that many organizations that could demonstrate overall formal practices. It doesn't say that they don't have practices in place, but do they have formal practices that can address the overall supply chain risk and issue that is present today. With that said, interesting article that had an opportunity to read, and it looks like first quarter analysis says the supply chain attacks overall have risen by 42% in the first quarter of 2021. Cyber attacks on the supply chain are increasing 12% quarter on quarter, with the number of affected in each breach increased by 564%. So, certainly from the standpoint of, I don't think any organization that operates and functions today in certainly an environment where information technology and the ability to use data and have to store, process, transmit information, certainly from a sensitive and regulated standpoint, they are susceptible to risk. And those risks are extremely real based upon today's adversary. And from that perspective, and knowing that, certainly the challenges that providers have to make sure that, they can adequately understand where the vendors that they enter into relationships with, do they feel and meet the organization's risk tolerance and able to, store, process, and transmit their sensitive information. So certainly a key fact, and to know where, just how other industries are addressing this right now. I don't know if how many folks are, pay attention to outside of healthcare. I do know that the Department of Defense, which has been in the news, certainly with, the attacks like SolarWinds and others that have occurred, they are in the process of trying to implement a formal certification and overall cybersecurity maturity model for all of their supply chain vendors. So I certainly hope as that process matures, and it's not there yet, they're in the infancy stages of determining exactly how they're going to execute that, that process to get all, anybody that wants to do work with the Department of Defense would have to certify under that cybersecurity maturity model. It'll be interesting to see in the future how other industries, can and should adopt that model. So I would certainly, this is a personal opinion, would like to see some of that burden and responsibility shift from the provider having to, attest to or accept that risk, where the vendor has to demonstrate that process. And it would be interesting to see, as we move forward. And I don't think this is certainly a near-term thing, but as that particular process with the DoD gets gets implemented, I know other industries that are considered critical infrastructure will hopefully adopt that process. So, we are certainly keeping our eye and focus on that. And synergistic, we have a division of synergistic Redspin that is certainly a part of that overall certification process. So we're keeping abreast where that goes. Go ahead, next slide. All right, overall, just a little bit of information for certainly for those that are new, and just to hit the highlights on why are we having the discussion certainly around supply chain risk management, and really how is it impacted with the industry. So this is not at the individual level. This is where are the problems that exist inside the industry overall from a cybersecurity perspective, and certainly how that translates in the ability to understand risk as it associates with your vendors. When we looked at all of our assessments, what we found was overall the industry improved. At least that showed by the data in the average. The reality to that was, when we really looked at the numbers, is that we had a small portion of the organizations that scored very, very well on the NIST, and still a large portion of the organizations that we assessed using the NIST cybersecurity framework were still below that conforming line. And what we want to see, and where I believe the starting point is that line in the sand, that conforming line, says that you have a process, it achieves its purpose, and it's well defined. And when you have those processes, that's where you can ultimately determine, are those processes effective? Is the control that I'm implementing established and formalized in order to put ourselves in the best possible position to mitigate the risk, as well as keep abreast in today's threat environment. Go ahead, next slide, please. Now, another thing that the data said was, it didn't say that organizations didn't improve. And what we did see is we had many organizations, as you can see in the graph, where groups of organizations that made improvements on their conformance. And what we mean by conformance, we say how many of those controls that we assess, those 23 control areas, have those established processes. So from a scale perspective, that 3 or higher. So the good news is, a lot of organizations did show improvement, and that's a great thing. You want to have a program in place. You want to be able to continue to improve that program and try to stay ahead of today's cyber threats. However, overall, we're still opportunities there. The industry is still lagging and far behind. With all that said, the area that certainly has, I think, the most opportunity to improve is that supply chain risk management. Go ahead, next slide. All right, so the supply chain tenant lives inside the identify functional area of the NIST CSF. If you look across that control set, so you look at, do you have all your total control over your assets? What's your business environment? Do you have a governance model in place? Do you assess risk? Do you have an overall strategy? And then ultimately, that supply chain risk management. If you look across that whole section, some of the areas that certainly impacted why this was an area that did receive the overall lowest maturity scores is really just lack of knowledge or control of everything that's plugged into the network. Now, that's a really technical statement, but what it means is, if there's something plugged into the network, it generally comes from a vendor, generally comes from some product or service that is, performing services, inside the environment, and getting control, positive control of everything that gets put on the network is the only way you can ensure that did you assess risk of that particular system and or asset? Does the asset have the right safeguards that are in place? And does the vendor, meet the criteria that is outlined in that business associate agreement, as well as, are they the right partner to be able to say, can they store, process, transmit your sensitive information on your behalf. The other thing that we found, which was a common theme, was that informal practices. And I think, from how most folks, talked about or answered the poll questions, it isn't to say that folks don't have practices. It's to say that, these things don't happen overnight. A lot of the practices are informal, and still there's opportunities to mature those practices and make sure that that you can assess risk. The other issue that we did see is certainly the impact on mergers and acquisitions throughout the industry. We deal with many folks that have mature programs that are entering into either acquisitions, they're being acquired, they're merging with other partners, entering into other business relationships. And when you do that, it certainly then changes that whole environment, changes the landscape, changes the risk posture, your processes, and sometimes can set folks back from the standpoint of assuming all that risk. So it's extremely important that throughout those types of processes, that not only do you have the ability to provide the right risk assessment of that vendor, but what is the impact on that merger and acquisition? How does that impact the vendors and things? And that's what we saw some of the challenges for most of the industry. Go ahead, next slide. All right, I'd like to jump into overall security perspective, and I'd like to talk about three topics. First and foremost, the first thing I want to mention from the security perspective, and I use the word formal, is the ability to identify, develop, implement formal practices to evaluate vendors prior to procurement. I'm not saying anything here that I think everyone on this call doesn't know is needed. I think these are the biggest challenges when it comes to working in an environment where there may not be formalized buying practices. I think those are things that generally most organizations are trying to get their arms around. Usually, what we see is that when someone can get in front of the procurement decision and can apply the appropriate risk assessment, to that system, that then they can make an informed decision. So I think the formalized practices are not just, do you have the ability to assess risk, is do you have the ability to identify all the things that you have to assess risk from? And that includes your overall supply chain process, the buying practices, as well as making sure that whatever avenue your organization has to expend dollars, whether those are operational or capital dollars, is there a process in place that can identify it, and then the right risk can be assessed, for that. And a lot of organizations have great practices moving forward, and they establish those practices, but there's still opportunities, and it takes a while to then go, backwards looking and ensure that they can, understand everything that is plugged into that environment. So the other part of this that makes that process that we talk about, the formal practices to assess risk, from a risk assessment perspective, that process is not usually difficult to achieve, in the sense that your security teams and IT teams can come up with what they want to evaluate. They want to evaluate what type of system it is, how is the application deployed, what network requirements are there, how does it talk, how does it communicate. Those are generally things that most IT shops and security shops know that they have to find out from an IT perspective. Then there's the vendor perspective, and usually, once again, there's not a lot of challenges when it comes to determining what you need to identify, from that vendor. Where the challenge exists is, does the organization have a risk tolerance? Does the organization have the ability to accept risk? And ultimately, who's going to make the decision on whether they accept risk or not based upon those responses? So it's extremely important as you move forward, in order to certainly address the supply chain management is to really understand, do you know what the organization's risk tolerance is? What will you do in the event that a vendor doesn't answer questions or doesn't present objective evidence to you that you feel is adequate or that meets your security requirements? Do you have the ability then to manage that, to either have some component of the business or governance be able to ultimately accept or reject that risk? And I think those are challenges today. Certainly, those things are generally looked at from an IT and security perspective, and sometimes can be very, very challenging from an overall business ownership perspective. So certainly opportunities there. And the last thing that I wanted to talk about in this perspective, where I see this industry has to embrace and do things that traditionally are not generally accepted practices, and this comes down to even what the vendors are currently doing, is can you validate that whatever that vendor is providing to you from a hardware and software perspective was developed using sound coding practices? So, can they attest to, secure code reviews? Do they do things like penetration testing? Do they do, testing prior to them putting that system into a production environment? What are their software development lifecycle practices as they, how many releases a year do they do? What type of testing do they do on those systems prior to them releasing those versions to you? And generally speaking, most folks today are just attesting to general answers of questions and not necessarily providing any objective evidence as do they perform that level of testing. Now, does this need to be done on every system? I don't know. It depends upon your risk tolerance, and it depends upon what organizations decide their risk tolerance is. But I would know, and Ratana and I have had this conversation many times with our clients, is we don't believe all vendors are created equal from the standpoint of what their responsibilities are to either safeguard, store, process, transmit your PHI. So, ultimately it comes down to having the ability to identify, what those vendors, what are those vendors that introduce a higher level of risk to your organization, and what are the requirements that you want to see from them in order for you as an organization to make a sound risk decision. So, Ratana, I'll ask you if there's anything that you'd like to add to to those comments. Please feel free.
Yeah, thanks, Dave. And so some of the other things that we also mentioned with our other clients is like also communicating those standards and expectations of the organization's minimum requirements when it comes to evaluating your vendors prior to procurement and doing the pre-screening and pre-assessments and all the security risk assessments as well. So, that could be inclusive in rolling up to determining up to the risk appetite for tolerating the risks that are going to be identified from your screening process. A lot of the things that the vendors provide that may create more risk to your environment or just to the operations of your organization. And so just kind of keeping in mind, as what Dave was saying, and taking a look at their secure coding practices and a lot of if they've done penetration testing, it's also good to kind of evaluate, just making sure that you have the appropriate controls in place to be able to implement any software solutions or tools that they're offering you, because keeping in mind that what their controls and their configurations are meant to protect their solutions and tools, but the ultimate responsibility still lies within you to secure your network, to allow the system to be able, or tool solution to operate within your environment from theirs.
Yeah, no, Ratana, thanks for that, context. And I'll add, I think if I could just sum all that up, because there's a lot there, certainly. And I think where the challenges are is if we look at, where do we come from with vendor risk management? What are folks doing today? Like what are the practices that are happening today? And what are the practices that we need to implement moving forward? I personally believe that we have to implement practices that move beyond just an attestation component to vendor risk, determining what your risk tolerance is, determining what you feel you need to know in order to make decisions. And, the best way to do that is in the front end of the process. Can you impact the contractual arrangement? Can you ensure, and what do you need to ensure? What is that objective evidence that you need to determine in order to satisfy whatever that risk appetite, risk tolerance is? So, all right. With that said, I'd like to move to the next slide. All right, I am going to turn the presentation over to Andrew, and we'll certainly be back here for additional comments. So go ahead, Andrew.
Hey, everybody. Thanks, Dave and Ratana, and good afternoon, good morning, everybody. My name is Andrew Muller. I'm the Director of Privacy, Compliance, and Managed Services for CTEK. I've been here for a number of years, and prior to my work with Synergist Tech, I've served as a privacy officer. I've been in research compliance, and then prior to that was an investigator with the Office for Civil Rights, and worked on lots and lots of cases, even leading up to some of the work around business associates in 2013 and beyond. So I'm really happy to be talking with you today, because something that is it's I don't know if I'd say a passion exactly, but it's something I have anxiety about, and that is the collaboration that really should happen, needs to happen between information security or IT, contracts, procurement, privacy, compliance, legal. There's a lot of moving parts that need to be working well in order to do vendor management in a way that really significantly minimizes risk and ideally puts you in the best posture. So I'm going to talk a bit about data privacy generally, and how the intersection between privacy, security, and vendor management, and then I'll give a brief enforcement update as well, just to talk through some of the more recent pain points. This is, I think, an important statistic just to have in the back of your mind. This is a more recent study. 80% of data breaches originated with a third party. And almost 30% of companies have no visibility into the security of their third-party partners. That can be frightening, just knowing how imbalanced those percentages are, and hopefully, you collaboratively, we can all talk together today about ways we can, maybe make that a bit better for your organizations. Okay, next slide. And this comes directly out of the HIPAA Audit's industry report that OCR finally published at the end of last year. I'm going to talk a bit about this in just a minute, but something I really want to point out to you as part of their audits that they conducted, this goes back several years, 12% of business associates fulfilled the requirement to implement appropriate risk management mechanisms, only 12. So, I sort of felt like stopping there, because that's not a very high number. While few audited business associates reported a breach of EPHI, OCR found that those that did generally evidenced minimal or negligible efforts to address audited requirements. So again, something just really, not trying to scare you or scare your organizations, but it's important for you all to have this information. It's important for your senior leadership and management to have this information, so that you can really help manage risk and put your compliance posture in the best possible position. Next slide, please. Okay, so I wanted to just do a quick baseline here, because I know that, when some people hear vendors, they hear one thing. When some people hear business associates, they hear another. So I'd like to level set a bit and just define a business associate, because I think that's really important when you're thinking about risk and regulated data, particularly around HIPAA, but it doesn't have to be around HIPAA, right? A business associate is a person or entity that performs some functions or activities that involve a use or disclosure of PHI on behalf of or in support of a covered entity. A covered entity's contract or other written arrangement with its business associate, it has to have certain required elements. So when a covered entity, and this can be a provider, this can be a plan, when they're contracting with third parties or vendors, and it involves some sort of transaction around protected health information or EPHI, I think most of you know on the, in this room that there has to be a business associate agreement that accompanies it, and that BAA has to have certain core elements and required statements. So you can already see just from the business associate process, all of the different offices and people that really should be involved in these discussions. You really need to have somebody that has designed a business associate agreement or who knows how to negotiate a business associate agreement in a way that's compliant. You want to make sure that whatever services we're contracting for actually involve PHI or EPHI. And so many discussions need to happen around vendors and business associates and risk. An important note here, business associates can be vendors, but not all vendors are business associates. So again, something to keep in mind as we go through the presentation today. Okay, next slide. 10 myths about vendors and HIPAA. And I'm using HIPAA specifically as the rule or regulation, but again, just know that depending on the jurisdiction that you're in, if you're in certain states, if you're interacting with certain international laws, you're going to have some similar obligations around vendors. It's not going to be just a best practice to do some oversight of vendors. It's going to be required, or it's going to be inferred through enforcement. So let's go through the 10 myths and just sort of talk through each of these. 10 myths first. All vendors are business associates. As I just mentioned, we know that's not true. Business associates it's a defined term, and one way to help manage risk within an organization is to determine which vendors have regulated data and which vendors do not have regulated data. Another myth that I hear pretty frequently is we can't assess every business associate. And I know from being a privacy officer, I know from talking with a lot of clients, that it can be very difficult, especially for those of you who said you've got 500 or more vendors. Many of those may be business associates. That's a lot of work to do. I have also seen organizations that have hundreds of business associates, if not thousands, put together a work plan where they've been able to methodically over time get in contact with their vendors and business associates, understand their security and privacy practices, and perform some type of assessment of them, whether it's during the contracting stage through some type of a questionnaire or periodically throughout that relationship. Next myth, BAAs are always optional. Again, we know that at least in the HIPAA space, that's not true. If you are a business associate or you're contracting with a vendor that's dealing with your PHI, you have to have a business associate agreement, or at least all of the core elements that are required in the rule. Another one, the privacy office, and you can insert any office here. The privacy office is probably tracking all of them. I've seen a lot of organizations where, IT, handles vendors and business associates one way, and they'll say, well, for everything else that's not EPHI, I'm pretty sure the privacy office handles that. And the privacy office may be saying, for anything that's involving technology or EPHI, the security office handles that. It's really important for organizations to collaborate and understand where the business associate agreements are being tracked, where the risk is being tracked, where the vendors are being tracked in some sort of a cohesive collaborative process. Number 5, the only vendors I need to worry about are vendors with EPHI. As I mentioned earlier, there's lots of other rules, regulations, and laws. In addition to sensitive information, data that may not be protected by HIPAA, or even maybe another rule or law, but you certainly don't want to have, a breach involving or an incident involving that data, because it could be really bad for your patients, your consumers, your clients. It could be bad for your own organization. HIPAA only pertains to providers. We know that HIPAA also pertains to business associates. Business associates have been audited, which I'll talk about in a minute. They're frequently investigated. Business associates also have obligations under HIPAA. HIPAA is the only rule or law that provides requirements about vendors. I already touched on this a minute ago. We know that that's not true. I have no responsibilities at all if a vendor experiences a breach. So sometimes clients will say, the vendor really has the responsibility here. We're giving the data to the vendor. They have to sign the BAA. They sign the agreement. They have the obligation under HIPAA or whatever rule or law it is. And if there's a breach, even if it's our data, that's their problem to manage and deal with. And depending on the contract, depending on the business associate agreement, that may not be true, and it may not even be appropriate. You may not want, for those of you that are working in covered entity spaces, hospitals, health systems, providers, you may not want a business associate notifying your patients or your consumers if your patients have no idea that business associate is even involved in their protected health information. They may not even know the business associate's name, and it may scare them, and it may cause more confusion than anything else if they're getting lots of notices or getting information from organizations they aren't even aware of. In addition, the BAA or the contract may say that the covered entity has the obligation to notify or to do the reporting. At a minimum, there should be a conversation between vendors, between business associates, and the contracting party to really understand what the incident is, what happened, go through the steps to figure out if it's a reportable breach or notifiable, and either close out the investigation or take whatever necessary steps are needed. HIPAA requires constant monitoring and assessment of vendors. I also hear this where people will say, well, we can't assess every, we're doing our best because we know HIPAA tells us we have to assess every vendor all the time. It's not true. It's certainly a best practice to be performing assessments of vendors. At some point, you certainly have to have some oversight of your vendors. You heard a bit from Dave earlier and Ratana about the risks there and the requirements there. But I think it's appropriate to level set there that there isn't a specific requirement in HIPAA that requires some kind of constant or even periodic assessment. We just know there has to be some due diligence. And similarly, HIPAA requires an annual assessment of vendors. It doesn't require that either, but it does require some sort of due diligence and oversight. And certainly your business associate agreements and your contracts will infer that there is going to be some oversight, and that oversight and those conversations and communication is going to be appropriate and necessary. You can go to the next slide. All right, so a few thoughts here. Again, just kind of coming purely from a privacy perspective, but also being in roles where I've worked with legal offices, I've worked with IT offices, I've worked with compliance offices. You'll continue to hear from me today the importance of bridging these groups and these offices to really have an effective program. Some things to think about. Does your organization treat vendors and business associate compliance differently? Do you manage the risk differently? Maybe you do. I think the most important piece there, whether or not you're treating them or dealing with them in the same form, fashion, through the same agreement, that maybe isn't as important necessarily as it is making sure that you and your offices and leadership and management have a real understanding of the risks that are involved if you're treating all vendors like business associates or all business associates like vendors. There can be some risks there, and it's important to have those kinds of difficult conversations. Something that I just mentioned, and I'll probably say it on every single slide, vital to have clear collaborative processes related to business associate agreements. We know that IT has a process. We know the privacy office has a process. We know legal maybe has a process too. But if they're not talking to each other, you're going to end up being in a position where you may have a request from OCR, you may have a request from another regulator, an AG or others about your vendors, and you're going to be scrambling to figure out where the agreement is, who actually contracted for the service, why we contracted for the service. It's really important that there is some, whether or not it's a centralized database or just clear process and communication. Very, very important that you have those processes in place. Has your process ever been reviewed by a third party? Have you ever had even an internal audit? Have you had an internal audit or an external audit around your business associate agreement and vendor risk management process? It can be very helpful to have, again, whether or not you're relying on an internal audit group or an external group, very important and helpful to have somebody else within the organization provide some of that feedback around risk and feedback around gaps, so that it doesn't fall on the compliance people or the IT people to go back to somebody who wants to contract for their service to tell them, the risk is too high. It can be very helpful to lean on internal audit or external third parties for that sort of support. Where are business associate agreements? So where are they being stored? Where's the template? Where are the executed business associate agreements? And really who's responsible? Who's ultimately responsible for making sure a BAA is included when it needs to be? Who's responsible for making sure the template that your organization uses is actually compliant? And then in those cases where a vendor or business associate pushes back on your template and red lines, like I'm sure none of you have ever had Microsoft or Box or Dropbox do this. But when they come back with red lines, who's responsible for doing the proper negotiation? I think it works best, at least when it comes to negotiating or redlining BAAs. I think it works best when privacy, legal, and IT, again, are working together on that. I think from a template business associate agreement perspective, I think it tends to work really well when you have a privacy office that owns that responsibility. Certainly that doesn't have to be the case, but it tends, when you have key stakeholders and experts who are the ones overseeing the process, you're going to have a much more of a compliance posture that you and leadership feels comfortable with. Who's reviewing, and are you reviewing existing contracts and BAAs? I know many of us, with the omnibus rule in 2013, we performed this extensive review of all of our business associate agreements to make sure that we had the updated language and the agreements were in compliance. But for a lot of us, it stopped in 2013 or 2014, and we never did it again. We never went back to look to see, that the BAA or the agreement that we used in 2017 was truly the right and updated template, and it wasn't being, the old or outdated template wasn't being used or pulled out of a drawer. It's something that is very important to do, vital to do, is to go back and have some kind of a process where you are reviewing existing contracts, BAAs, to make sure you've got a BAA in place if you need to. If you don't need a BAA, somebody should ask why. Why do we have it here? Because maybe that introduces some risk to us or obligations that we don't need. And where do we go if we need to make changes? And then finally, and this is something that me and my team, we see frequently, the more that HIM and medical records groups and others are outsourcing medical records and the facilitation of access requests to third parties, we're seeing some significant risks there. So you have to think about not just the privacy of your patients or clients or consumers or members, but also all of those individual rights that they have under HIPAA or under other rules and laws, particularly something like the right to access their information, or at least to request access to their information. If you have a third party doing that on your behalf, who's ultimately the one that's providing the records back to the patient, you want to make sure that they're complying not just with your policies and practices, but also with the state law requirements and with any federal or any other requirements that they may have related to individual rights. So, you don't want to be in a position where you have an external vendor charging excessive fees, for example, to your patients, or not responding in a timely fashion, because ultimately that can fall back on you, and you may be in the position where you have to answer some difficult questions. So with that, I think we can go to the next slide. And I'm going to go through the enforcement piece pretty quickly. I think it's important to cover, but I want to make sure we've got a lot of time for discussion too. So, hopefully we'll have opportunities to talk, if not later today, in the future. I did want to mention the HIPAA audit industry report, because this is something that if you haven't read, you should read it. You should go through it and at least look at it, have somebody in your organization look at it and summarize it for you. OCR finally released their industry report from the audits going back to 2017 or so. And as part of those audits, for the first time, we had OCR auditing business associates in addition to covered entities. And we've got some information about how business associates were able to comply with HIPAA. And that may also help you, for those of you who are working in covered entity spaces, or even business associate spaces manage the risk appropriately and really build good processes around. Something I want to mention here on this slide, I'll just highlight the rating scale for you, so you kind of get a sense when you see the next slide what we're looking at. What you want to know is that 5 is bad, and even a 3. So if you look at the score for 3, the audit results indicates the entity's efforts minimally addressed requirements. So they made some attempts to comply, but it's inadequate. So really think about, 3, 4, and 5. Those are areas where things start to, not look so good. And then here on the other slide, here on the other graph, you can see the types of business associates audited, and it gives you a sense of the areas where OCR was focused and where they wanted to dig deeper. So of course, billing and claims, electronic HR, and so forth. I was interested to see that IT was not at the top of the list. Certainly billing and claims and electronic HR, that many of those touch on IT systems and information security, but I did think that was an interesting aspect to the results. Next slide. All right, so here we have OCR's report back to us about business associates that were audited and their compliance posture. And you can see here the bulk of the findings, the bulk of the ratings did not look so good, right? You've got a lot of 3s and a lot of 4s. And if you think back at 3s, which were, basically they're minimally compliant, 4s making negligible efforts or not much of an effort by way of compliance obligation, that's a little scary. And here, what we're looking at here in terms of the audited provisions, the first is notice to covered entities. So we're thinking about our business associates and vendors, are they appropriately notifying the covered entity of an incident or breach? Do they have a good process in place? And then the 2 heavy hitters here that those of you who are IT professionals, live and breathe every day, which is the RA and risk management. Things are not looking so great. And this isn't, we're not talking about 2013 or 2010. We're talking 2016, 2017. Certainly things have improved since then, but it still should be a bit of a wake-up call. Next slide. Thank you. And I'm going to go through some enforcement examples for you, and then we'll turn it over to Ratana, and she and I will talk a bit about some compliance efforts. I highlighted some recent enforcement efforts that where you can see the Office for Civil Rights focusing either on a business associate or focusing on a business associate relationship, and hopefully again helps you think about risk. These are things you can take back to your office, take back to other key stakeholders in your entity to help build a network to create good processes. So here we've got very recently, we had this resolution agreement come out from OCR. Clinical lab, they pay $25,000 when the Department of Veterans Affairs reported a breach that involved their business associate. OCR dug pretty deep into this, into this investigation, found lots of non-compliance, and ended up fining the clinical laboratory. The next one, Aetna, we don't have all of the details here about Aetna that's public, but I think you can make some inferences. And I think, even if some of the assumptions are a little wrong here, I think it's still helpful to think about. And I'm sure many of you still have some similar, chest pain around this. Aetna pays $1 million to settle 3 HIPAA breaches. Again, very recent settlement. And what are the 3 breaches? Well, you have in one case, 2 web services that are used to display plan-related documents about the health plan. They allow the documents to be accessible without login. They were indexed by search engines and so forth. This to me seems like it's very possible that those web services were, these were contracted vendors. It could have been groups inside, certainly, but we know that, many of us and many of you use vendors to assist with patient portals, to assist with other types of web services. And the next 2 are around mailings. So benefit notices mailed using window envelopes mailed to the incorrect patients. And then we've got a research study mailing malfunction. And again, this is an area where many of us are using vendors to help us with our mailings, to help us get notices out. We may even just defer the entire process to a vendor. And again, Aetna ended up paying the bill here. So things to consider. Next slide. And then the final two, I'll point out, you've got a huge business associate agreement penalty here, almost $2.5 million. And when you see these numbers, these are just the amounts that were paid directly to HHS. So this doesn't include, all of the costs to notifying your individuals, doesn't include any litigation costs, doesn't include, standing up a call center, all of that. So these numbers, of course, get much higher than what you see here. So $2.3 million. What happened here? You've got a vendor that provides a lot of business associate activities, including, this is what I mentioned earlier, IT and health information management. So here in this case, we have some direct enforcement against a business associate here involving a persistent threat group. They're paying a lot of money, right? And these are things that OCR is focused on and cares about. And then finally, a healthcare provider pays $100,000 so they start investigating a doctor's office after it files a breach report. And this is sort of interesting. This is related to a dispute with Dr. Porter's one of his other companies, one of his other business associates, when there happened to be some dispute around finances, and his business associate said, well, we're not going to give you any of your patient information until you pay us. And OCR took a very hard look, not just at Dr. Porter's practice, but also this group Elevation 43. And really the bottom line here is that it's, having processes in place, having good, clear communication, having some sort of vendor oversight program is going to help you minimize the risk. It's not going to eliminate these things from happening. It's not going to eliminate OCR's enforcement or an AG's enforcement practices, but it's going to put you in a much better position when something does go wrong. Next slide. Okay, and so for this, I'll ask Ratana to join me. She and I will talk through the compliance perspective together. I think it's, I'm hoping, Ratana, we can have just a back and forth conversation about this, because we've talked about IT earlier, talked about data privacy, and now we're kind of weaving it together with compliance and maybe some best practices too. So I'll let you start off the slide, and then I'm happy to chime in.
All right, thank you, Andrew. Good afternoon, everyone. My name is Ratana DeLuca. I'm one of the information security consultants with Synergistic, and I focus specifically on the enterprise risk assessment from a HIPAA, NIST, and compliance perspective. So that also includes the third-party risk assessments and supply chain management assessments that's incorporated in the RA that most of you typically receive. So prior to Synergistic, I was actually the Chief Compliance, Privacy, and Information Security Officer for a healthcare organization provider for a number of years. Part of that role also included managing and evaluating third-party risk. That included the vendors, our contracted healthcare providers, and business associates. And also part of that, I also helped manage and develop a centralized contract management program, and developed a lot of the organization-driven templates for contracting for service agreements, provider agreements, data use, sharing agreements, and business associate agreements. And so what we're going to be speaking to in this particular area right now is going to be from a compliance perspective and managing third-party risk. And starting off, we are going to actually speak to kind of like the contract process. The contract review, due diligence reviews, and negotiations, kind of tying in with what Dave and Andrew kind of mentioned earlier about, managing vendors and business associates, doing the risk assessment screenings, and communicating the organization's minimum requirements from a privacy, security, and also HIPAA perspective overall. A lot of the problems that I've seen over the encountering with other clients, just in my own years of experience, is also just getting the right people in the door to actually do the reviews, the contract reviews, and the discussions of the procurement process in advance. When you get the contract, it goes to your legal counsel and they review the contracts, but they only review it just to the extent of how the organization is going to be protected from a legal perspective. The other parts of it ties into the risks that should be identified at the subject matter expert level, and those would be the people from IT, security, compliance, and all those other components, those other areas as well, to be able to, just to be able to kind of get them to weigh in on the transaction, make sure all of us are identified in the contract terms are going to be appropriate to support and protect the organization in the engagement. The other part of it also is, the negotiation factor as well. So not negotiating hard enough or deferring to the organization's contracts and what they're willing to provide, and not pushing back enough to the things that the organization needs, and that's always going to be a bigger challenge is when you get to the larger, the larger vendors and the commercial ones who, have services, across the country and, or even globally to that regard. And so,
it's important to think about too, as you're, we talked a bit about the IT side and the data privacy side or the HIPAA side. When you're thinking about compliance, you're not always just thinking about the HIPAA rules or GDPR or CCPA. There may be state law requirements, there may be internal policy requirements, there may be legal requirements that legal has regarding contracts, whether it's a business associate agreement or a relationship or not. And it's really important that any negotiation that happens around these agreements are happening, not happening in a vacuum, and happening in a way where there is a good conversation around which template are we using, which template can we use, what language can we accept, and what language are we unwilling to accept because we can't, either a legal requirement or some other requirement.
And that's one of the other things that a lot of agencies also need to be able, and organizations need to be able to realize, is finding out what they have the authority to do as the provisions that they indicate under HIPAA, like required by law or whatever you have already contracted with another provider. So that goes into the data use, data sharing. Do you have the authority to be able to pass on the responsibility and obligations of managing data to a business associate? Is it your data that you actually own, or does it belong to the state or another regulatory agency to manage also as a business associate?
Yeah, fantastic. I completely agree. There's a lot of moving parts, right? And then, finally, when you think about, and we'll talk a bit more about this in the next slide, and I know we're getting close to time. I want to make sure we have discussion, so I'll try to move a little quickly. Accountability enforcement, what enforcement mechanisms do you have in place, either in the contract or in the business associate agreement or something else, where you can really have true accountability over your business associate, whether you are a covered entity, an upstream contractor, or whether you're a downstream vendor from another business associate. And then finally, what's happening after the execution of the contract? How is it being validated? How is it being reviewed? Or is anybody going back to look at the contracts or the process to see what sort of oversight is either required or needed, or potentially not needed, because maybe they're not dealing with any type of sensitive or regulated data. Bertana, do you have anything else to add?
Yeah, I would say, going to the accountability enforcement and post-execution validation review is just doing the trust but verify process, just making sure that what they promised to deliver or promised, within the contracts to give you is actually the thing that they actually provided you with. And, and then that you have that true sense of security to be able to, continue with this engagement.
Great. We can go to the next slide. And then this is, the question we get all the time, what about vendor non-compliance? What can we possibly do if we, assess or audit a vendor, review their compliance posture, review their IT systems, and we find non-compliance, either in a small way or maybe systemically? What can we really do about it? Because we have to have this vendor to do X service. And so we've added here some things to think about. Some of them may be no-brainers. But you do have options, whether you're in a compliance office or an analyst, or even in leadership or management. There are options that you have and things to think about as you are dealing with a non-compliant vendor. Ratana?
And so,
I don't know if you had anything to add to that.
well, I guess that kind of goes back to just the enforcing that accountability and having processes and plans in place to address non-compliance, as you mentioned earlier, and following through and having the support to be able to implement, any sort of remediation plans, whether it moves forward to, saying that they're in breach of the contract or even giving the termination notice and such.
Yeah, so it's, you can think about this up front, right, through adding certain requirements to proposals or renewals. You can periodically review the agreement with the vendor. You could do a screen share, do something, in real time with them to help them understand their obligations. Of course, you can assess them. And, as you continue to find potentially systemic issues or a vendor that's not responding or stonewalling you, these are things to escalate to leadership. So there can be a real conversation around business need and business risk. I've been in positions where I've provided alternatives, and I've said, look, this vendor is just too risky. They're non-communicative. There have been a significant number of incidents. We need to find something else. And so what are some alternatives to the service as we start thinking about what our options may be? And then, as Ratana mentioned, finally, you can give notice and terminate it. And I think, that's a valid thing to do. I think a lot of people feel uncomfortable doing it. But I've seen it happen before. I've participated in it, and sometimes you just don't really have a choice because the risk is just too significant. Next slide. I think with that, we're kicking it over to Dave. We may have lost Dave.
All right, everyone. Can everyone hear me? Great. All right. Ultimately, as I close this out and looking forward to having an opportunity to answer any questions that this group may have, I want to thank Andrew and Ratana for providing their insight, both from a security, privacy, and compliance perspective. We just want to leave with some summary of the things that we discussed today. Obviously, pre-screening in front of the process, I think that's the most successful way organizations that have the ability to address risk and apply whatever they determine their security requirements and have a process that can do that due diligence and determine whether that vendor can meet that due diligence is the most successful piece. Where I see that moving forward in the future is going to be moving beyond just asking them to attest and determining what objective evidence and what is required by that vendor in order to validate or demonstrate that effectiveness. So I think that's where the future is going there. Certainly, making third parties a part of your formalized risk management plan. It's important to make sure that means, do you have a risk tolerance? Do you understand risk acceptance? Do you know who determines that? And what happens in the event that vendor comes back with some answer or objective evidence that doesn't meet your standard? What do you do about it? Do you have that process? Is it something where ultimately you can tell your risk story? For those of you that know me, I talk greatly about the need to be able to tell your risk story. Is it something that you say, yes, we evaluated it, and this was the decision that we made. We either accepted that risk, we mitigated that risk, or ultimately, documented some plan that says here's how we're going to address it. Comprehensive contract negotiation and strategy. Make sure that all players, to include compliance, privacy, contract, legal, are a part of a process, and everyone knows what their responsibilities are in that process. And the more that you can implement and integrate the overall risk assessment of that vendor into the procurement process, the more leverage and the more ability you will have to be able to act upon whatever ultimately that risk decision is. Post-execution implementation plan. Make sure that once it's there, what are the follow-on mechanisms? What are the abilities to provide continual validation, certainly from a compliance perspective, certainly from, your ability to say what happens now that that vendor has, met that requirement, you've assessed the risk, and you're using that vendor, will they then meet their obligations in the event that a cyber incident were to happen? And then periodic contract performance and validation reviews. I think what's really important, Andrew hit on a note that is really, really important, that ultimately what it comes down to is everything from this standpoint needs to be based on a risk process. So it isn't to say that, as he said, everyone's going to check that every single vendor gets evaluated the same way. No, but there's going to be some level of due diligence, best practice, and understanding in the event that there is a cyber breach that, based upon today's threat, what is important. And if you have vendors that are storing, processing, and transmitting your PHI and that are critical to your operations, those are vendors that you have to perform that level of due diligence. You have to at least look at what best practices. We look to NIST. NIST outlines that NIST cybersecurity framework. It outlines what are required from ultimately is needed to assess and evaluate risk of your supply chain and your vendors. And then ultimately, also from a NIST perspective and a compliance and privacy perspective, are you meeting the obligations that are required through whatever federal, state laws are associated with that? So with that said,
can I say one quick thing? Sorry to interrupt you. Something just to think about, because I know, I recognize a number of names on the call. I know we've got a number of security and IT folks. It's really important to recognize when Dave said, when you're thinking about where your data goes, it's important to recognize that data can be electronic. It can also be in paper. It can be transmitted a variety of ways or in a lot of different form and formats. So I think when we talk about vendor risk, a lot of times it's around information security and IT because there's a significant amount there. But that's not the only area where there's risk, and that's not the only area where there could be regulated data. So I just wanted to throw that out there. Thanks, Dave.
Right. Well, all right. With all that said, I certainly, this ends the first part of our session today, and we hope that would be happy to answer any questions that you all have. Please feel free to put those questions out in chat, or we can turn your camera on, or turn off mute and go ahead and ask us. We'd be happy to answer those for you.
And for the team on the call from CTEK, it may just be me, but I can't actually see, I can't actually add or see questions. This is an FYI. I'm not sure if others have that problem too, but.
Remember, you can unmute yourself and come on camera, or you can ask a question in the chat or Q&A button on the left side of your screen.
Well, I think while folks are, deciding what questions they may or may not have, I certainly would. I have a question for Andrew and/or Ratana as it relates to, what the term due diligence is. I think an interesting term, and how what is the best way to help navigate, I guess, what that due diligence is, and as it relates to, what is the current climate. I know that in times, folks say, we look to something that they want to be black and white, and it isn't quite black and white in the world of HIPAA, in my humble opinion. So what does that mean in today, like the snapshot of today? What is due diligence? And then what should people be looking at to say, how do I know what I'm doing is the right thing when it comes to that due diligence?
Ratana, you want to take the first swing, or do you want me to?
I can go up to bat first. So I would say due diligence is really fluid. It could be one of those things that's constantly moving, constantly morphing, just like with risk. I mean, it's going to be associated with risk in that perspective because the amount of due diligence that you would apply to a review or validation would be subject to the risk that of the transaction itself and the engagement itself, and that's being tolerated or accepted or mitigated in any way.
Thanks, Ratana, for that. We do have a question that just came in, and I certainly believe Andrew or Ratana can answer this question. Is who typically is responsible for BAA creation, review, and analysis?
I have seen it. I have seen it vary widely. When I would say I think it tends to work best when you have the experts who are involved in creating templates and at least experts weighing into it. And the expert may not always be general counsel because they may be doing a lot of other things. They may not be as involved in some of the risk questions that those of you in security or privacy or compliance have or know. So I think when you're thinking about any agreement or any risk process, I think it tends to work best when it sort of goes ground up, and you have the experts who are involved in the creation, involved in the process, involved in doing some periodic reviews, and then when necessary, escalating it up for feedback or for negotiation, or even for maintaining it. I mean, I've seen some areas where legal has said we're going to be the only office that has business associate agreements or the only office that has vendor contracts. And the danger with that potentially, I mean, I've seen it work very well, but the danger potentially is that when you're dealing with a complex organization, a health system, a health plan, when you're dealing with an academic academic health system where you have College of Medicine, College of Nursing, so forth, you're going to have a lot of contracts in a lot of different places. And if you have a regulator or if you have somebody coming to ask you for proof of compliance and the answer is, well, I know that legal or I know that compliance or I know IT, they're the only office that handles this. They may not have the contract. And so, all the more reason to have to really build collaborative processes around this issue. I don't know, Ratana, if you have anything to add to that.
I guess one of the terms for those on the call who are clients who've seen a lot of my recommendations is I like to use the term multidisciplinary team or interdisciplinary team when it comes to managing and evaluating contracts or going into any sort of engagement such as that, because it's not just the responsibility of maintaining the organization's operations in general is everybody and not just on one person. So, as far as like the subject matter experts and getting the buy-ins and weigh-ins from all the appropriate parties, from an advisory perspective and also from a stakeholder perspective, you get the right amount of management that's going to be supporting of the organization overall.
No, thank you guys very much. I certainly hope that answers the question. If there's any follow-up needed, for that, please feel free to, add that back into the questions. We have a few more questions that have come in, and the next one is around what our recommendations on reassessments would be after vendor M&A activity. I think I'll take a stab at this one and say that first and foremost, I think it is important to make sure that anything from a when do you determine risk has to be in line with what your overall risk management plan is. So if you have a risk management policy or a governing entity or guidance or anything that formalizes risk management, and that plan says you're going to conduct risk analysis at either a certain frequency or being met by a certain condition, make sure that reassessment falls in line with whatever that condition is. So that's really from the policy perspective is just, include that into your overall risk management process. Now, from an overall security perspective outside, are you doing things the way your policy says, I would certainly approach it from, the reassessment piece. I would approach it from what did the original assessment determine and what was the risk associated based upon that first assessment. So ultimately, I would look at whatever came out of that initial assessment, and then align that with your overall risk tolerance. So, for example, if that original assessment came out and said, "Hey, here's a list of critical or high risks," then that goes in line with whatever your risk tolerance is or your ability. I guess the first question is, and everyone is a little bit different as far as their business relationships of M&A, is what is the ability to be able to remediate those risks? Is it truly a risk acceptance, or is it truly where a risk plan can be generated, a plan of action can be generated, and something that can be tracked through that management process? So address the first one with what risks are there, determine then what that remediation path is. I think from that standpoint, as long as you're in line with what your risk management plan says, you're in good shape. It may drive you based upon your tolerance to do something quicker than that risk. Maybe it's something where you say, "Hey, we need to follow up sooner," and that's all based upon that risk tolerance. So everything will come out of that, that particular, overall risk posture. I still always go back to say that as long as you're in line with what ultimately the organization's risk tolerance is, that you'll be in good shape. I don't know if there's the one answer to fit that, as long as it addresses the risk and it's in line with what that risk says. And I certainly hope that answers the question. So is anybody, Andrew or Tana, would you like to add to that?
Nope.
All right. All right. The one other, we do have some good questions. This is great. All right. I'm going to go in, I think, in order. I apologize if I'm out of order, but I'm going to go in order. The first one is, the third question is, what are your recommendations for investigation and breach determination if the business associate causes the issue? Should the business associate be responsible or the covered entity be responsible ultimately for the breach determination? And Andrew, I'm going to say this one's in your court. And Ratana.
Sure. Yeah, I'll take a stab at this one. So we know that, and maybe we'll try to answer this kind of procedurally. We know that a business associate agreement has to include a requirement to notify the covered entity or notify upstream if there's been some sort of an incident or a breach, depending on how your contracts are worded. Because business associates are responsible for complying with various aspects of the privacy, security, and breach notification rules, they're also going to be on the hook for doing some sort of investigation. And I've seen it happen a couple different ways. I've seen in some cases where a covered entity has so many vendors and so much risk out there that they just tell their vendors and business associates, we want these 4 or 5 different bullet points every time you have an incident or a breach. We want to know, who it involved, how many people, what caused it, and whether or not you feel like it meets low probability of compromise. I've seen other organizations, particular ones with smaller number of vendors who have much more of a collaborative process where they will, the vendor will pick up the phone and actually call the privacy officer and say, oops, and then they'll work together to do a risk analysis together and determine if there is a reportable or notifiable breach. And going back to maybe the third question here, or maybe I don't know if it's second or last, should the business associate be responsible for that, and who should make the breach determination? I think ultimately it's the responsibility of the covered entity to make a decision around both of those questions. So a covered entity in theory wants to have control over the PHI, over their PHI, over the PHI of their consumers and patients, or data about their consumers and patients. And again, they don't, you want to do whatever you can to minimize anxiety and outrage when there has been an incident or a breach. And one way to turn up the anxiety is to send notices out to people where it describes some service that they weren't even aware was, going on, some company they've never heard of. And they're suddenly going to think, well, wait, I didn't know they were dealing with my data. This is scary to me. What's going on here? That's one way to turn up the anxiety. So I generally think, it's going to be a case-by-case determination. I think it, usually works best when the determination and the notification comes from the covered entity. But certainly, the business associate agreement or other contract can provide some flexibility there. I hope that helps.
And one other thing to kind of add on to Andrew's comment, let's say the covered entity is going to be ultimately responsible for determining the breach and the notification. That's where reviewing the provisions of the business associate agreement when it comes to breach notification or just the notification requirements of any sort of potential security or privacy incident is kind of critical when it comes to defining those, because a lot of the templates that are out there will indicate that, if the business associate determines that there's been a breach identified, then they will only report the things that they determined and assessed as a breach. Alternatively, to have more control over it is to require within those provisions to say that the business associate or third party should report any incidents that occur regardless, and the determination should be left up to the covered entity.
Thank you very much, Ratana. Another question that came in, I think this is an excellent question, is how do you handle the process of determining that a vendor has conducted a sufficient security risk assessment and reasonable follow-through mitigation? If it is protected under something like attorney-client privilege, generally counsel is very protective of any reports, and they only agree to share data of an SRA and vendor name that conducted the SRA. What recommendations would we have? What I will, this is, I don't think there is a single answer to this question, but what I will say is I think there are some tactics depending upon where you are in the process of determining risk with an organization, and some things that that you can do. And I hate to use the term this way, but what leverage do you have in the process with that particular vendor? And I think in the healthcare industry, and I'm going to make a very general statement, that the leverage is starting to turn. Most of the vendors up until this point, they've held most of the leverage. And I think as this process goes, we're going to start to see the leverage turn, because ultimately, if you're doing an evaluation of a vendor that you're going to buy their goods or services, it's a procurement decision, and it comes down to whether they will agree with what you're asking, of them in order to do business with you. So I know the situation is not as easy as and always simplistic in this environment. So with that said, I will say some of the tactics that I would recommend to you that I think could be, alternatives in the event that, from a client attorney perspective, they would not provide to you the results. If that request to that vendor also accompanied, other attestation questions, I would make sure that the attestation questions, outside of do you perform a risk analysis, I would include key components in that particular area, just so you can get an understanding of, from the attestation standpoint, do they have a security officer? Do they have a risk management plan? Do they have an incident response plan? Do they conduct exercises? Go through some of the key things that will also trigger for you as a security official or someone that's looking at it from a privacy and compliance perspective, whether you feel that they would, that ultimately they would meet your requirements. So I would gear my questions, in addition to requesting the security analysis, I would gear that, those questions to also help you uncover more information that would lead you to believe whether the organization has appropriate safeguards in place. If it's truly a technical evaluation, and some folks look at the vendor risk kind of two ways, they do general vendor risk attestation, and then there's some technical evaluation of the product and or service that the company may be providing. I would get and glean as much information during that technical assessment, to make sure, what security technologies do they employ? Do they have the right, processes and procedures in place? And a lot of times, vendors are providing technical specifications. There's actually technical interchange that goes on between, staff and entities that can help you draw that conclusion out. So those are some things and tactics that I would say, I think would help make that decision much better. I would like to see, moving forward, and I think there's a general comment I'll make. More and more vendors are becoming a regular and more standard practice for vendors to have to answer questions. More and more vendors are entering into business relationships with partners and or providers and covered entities, and whether it's an agreement that requires a business associate or it's actually another partnering agreement with another vendor, that those vendors are requiring it as part of that partnership, more evidence, more proof outside of, do you do it, yes or no? I think the more that you can allow or provide that a vendor the opportunity to answer those questions and make those questions a part of the procurement process, so that's a part of, hey, all your answers that you provide are going to be, evidence in this particular contract. It's going to be a part of, your not only just attestation, but you telling us and communicating to us that you deploy the right safeguards, or you have the right, practices and processes in place that can provide those, that right level of risk or whatever meets your, your particular risk tolerance. I would say keep asking and keep offering and I don't want to say force the vendors. That's not it. It's partnership. This is an ecosystem, but I also believe that the pendulum needs to shift to the vendor, and the burden needs to be on the vendor in order to say, listen, you're running a system that is critical to this business operation, and as part of that, if you want us to enter into a contractual relationship and us to buy your good and service, you have to meet these requirements. So I would say multi-pronged approach. Ask more detailed questions. If you feel based upon just a vendor name or yes, they did it, okay, you have that information. They're saying they have one, but maybe let's ask them some more questions to attest to that can help peel that onion back a little bit more.
Dave, can I add to that too? Just briefly, something that I think it's important to point out as part of the final rule, the final HIPAA rules. OCR actually clarified some questions around certification. There was a question that came up as part of the rulemaking process where people, a constituency group asked, well, can we rely on a business associate or a vendor's certification of HIPAA compliance, or a certification of an effective risk management or risk analysis process as just sort of carte blanche compliance? And OCR, as you would probably expect, they took the position that they're not going to endorse, certifications. They're not going to, really speak to that. And in fact, they go on to say that, even entities that have different kinds of certifications, can still be subject to enforcement, because it may not be the effective, effective risk management process. It may not be an effective risk analysis. So when you're relying on other vendors to help you, if you're doing some kind of a certification process around SRAs. I know that's not exactly where the question was going, but I think it's usually helpful to point that out to people that, the check the box methodology, it doesn't always work when it comes to regulators.
Yeah. I know it's a long and complicated answer. I wish there was a simplistic answer to that question, but like I said, I believe that there's, what we're seeing. I see a lot more, entities that are asking for things like high trust certifications. SOC 2 reports are pretty standard. Do they have any other framework certifications? And I think that's going to lead more and more to vendors knowing that if they want to conduct business in this ecosystem and provide a good or service, that the more that they can demonstrate to whoever's going to buy that good or service, it will is required, and we're starting to see a little bit of that shift come into play. I go back to the beginning comment about risk tolerance. If your risk tolerance is, hey, we're not going to enter into a business relationship unless we know XYZ, and part of XYZ is, do they have an SRA? Is it a framework assessment, and can they provide evidence that of the controls that they have implemented? And if that's what is your requirement, that's what you shoot for. That's what you ask of your vendors, and then be able to evaluate whether you want that vendor to process, transmit, store, be your partner, and host and maintain your ePHI data. All right. Let's see. I'm going to look through here to make sure I'm not missing any questions. And I appreciate the comments that are in here. And I think what I'd like to do at this particular time, unless there's any other folks that have any other questions, just feel free to jump in. I want to thank Ratana and Andrew, and ultimately the CTEK team for providing this platform and allowing us to come on and speak with you. So certainly want to say thank you, and just ask if there's any closing remarks. Once again, Ratana, thank you very much. If there's anything you'd like to close with, feel free.
No, thank you, everybody. Hope this information session has been helpful, and we're available if there's any questions.
Awesome.
Yeah, thank you, everybody. Just know we're here. So if you have other questions, don't hesitate to reach out to us, and always happy to jump on a phone call or answer an email. So if anything else occurs to you after this session, don't hesitate to reach out to us. And yeah, thank you for being here.
Yeah, I certainly echo those. Oh, go ahead, Carrie, please.
Oh, no, I just want to, thank this group. And really, I was thinking back through all of the sessions that we've had. And, I want to thank everybody for attending. Hopefully this has been some valuable information. And I just have a really quick poll. I'm hoping that if you have a couple of seconds just to hang on. This is more for the marketing team to help us improve our sessions for next time. So I've just enabled a poll question. How do you rate the CTEK sessions overall? How valuable were they to you? So if you could do a quick vote, that would be great. Okay, so thank you. Yeah, the votes are coming in, and overall, it's looking pretty good. So I really appreciate it. I keep let the votes coming in. We've got a lot of 4s and 5s. So again, thank you. And all of these sessions will be on the Eventry platform. And so pass them on to your colleagues and peers, and you can go back and reference them at a later date if you'd like. So again, thank you very much. And Dave, Andrew, Ratana, any last words?
No, I just want to say thank you very much. This is it's always good to to be able to have conversation. Certainly, I enjoy the partnership with everyone on this call, and appreciate the questions and comments, and look forward to be able to answer any additional questions. So please feel free to reach out. Looking forward to it. Thank you very much.
Great. Thanks, everyone. Have a great day.